This is Decent Way of People News. All right, not attorney, not giving legal advice. Educational purposes only. Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. Learn how to use your Second Amendment for knowledge. Okay. Um. So off to the right here, yes, you see any security that would. Let's pull that back up. I, any security that would give up a little liberty to gain a little security will deserve neither and lose both. All this security and you know calling the police to help us out and running to the judges every time we need anything, right? We're jumping in there waving our rights. So therefore, um, for security, let's quit banking on these people that we know are throughout evidence are liars.
Trains. So, okay, I'm just going to note that I went over this verbally with you, Mr. Benshoof, today. All right, so the court, having gone through the waiver right to counsel of Mr. Benshoof, is going to allow him to represent himself on the 10 cases. So, Mr. Roy, I want to, let's see, if you want to go ahead and withdraw, if you have that notice on any of these, but you may go ahead and take off, so thank you.
And just for the record, last time I wasn't in jail, and I checked the municipal court's website. It had, there was still rural Sercan or Cyril Mercan, I can't remember what you know her name. I think one of Mr. Roy's supervisors, even though she told me in writing that she had formally withdrawn from one or more of the cases, those 10 cases, when I looked on the municipal court website, it still had her name listed. So I would just ask that the court ensure that the municipal court website will reflect all 10 of those cases that I'm pro se on all 10 of them, to make sure that names are all
right. Mr. Roy, I'm sorry, Ms. Sirkin is, and you and Ms. Sirkin are with, I'm sorry, which agency?
Northwest Defenders.
Oh, okay, thank you. So if you could just make sure that Northwest Defenders Association is withdrawn from all cases, and then if there's nothing else, Mr. Bench, if I'm going to let Mr. Roy go.
Yep.
Okay, thank you, Mr. Roy. Okay, and then lower bench, a copy of that will need to be held on each matter. Okay, now. Okay, so all right, so Mr. Benchoof, now we are at the pretrial stage on your cases. So what would you like to do today? So and you probably already know this. The general options are you can set for the case is set for trial, or you can ask for a continuance if you need more time to prepare, investigate, and negotiate with the city.
I just want to add to the video for a guy, and I showed you the video that was posted, shot his wife and that he never had. These officers look awfully calm and collected, considering he's supposed to be some super duper criminal that shot somebody. And they sure are just nice and calm and relaxed in this courtroom with him, being such a big time criminal and took a lot of SWAT people to go raid his house, and all of a sudden they're not even scared. But that being said, if he even speaks to him one time, oh, officer safety.
Uh, as I said before, the court doesn't have jurisdiction to proceed. The court doesn't have jurisdiction to set a motions hearing. Everything that's been going on is a malicious prosecution violation of RS 59.62.11.
Okay.
So, I know, are you familiar with the lawsuit that I filed in federal court, which named most of your contemporaries, including, okay.
I am familiar.
So your name was listed in that, in the statements of fact, but you were not named as a defendant. You were one of the first judges that presided over a hearing which I wasn't even allowed into, which happened in the fall of 2020. And the same thing that has happened with these DB cases, namely lack of personal jurisdiction, lack of subject matter jurisdiction, happened back then. I don't actually have any animosity towards anyone, even the people who have pushed my son to the point of suicide and destroyed my church and retaliated against me for more than 4 years. I merely want the violations of the law to stop. I want my rights to be respected because, like the cane, it's the weakest thing. If we allow the city and the county to violate my rights, then it's basically a green light for them to violate anybody's rights. It's hard for people to even imagine that I'm still being prosecuted for the fact that I was grocery shopping for my son and I to buy organic groceries without covering my face in 2020. The city could not legally prosecute me. I've already cited Supreme Court case law, and I've argued that in court. So those cases, the court never had personal jurisdiction. The court was violating the United States Supreme Court case law as well as the Civil Rights Act to prosecute me for trespass, shopping without a face mask. Both case number 656-748 and 656-749 should be dismissed. Technically 656-749 because there was a trial that should be vacated, which is required pursuant to Supreme Court case law.
So, Mr. Benchoof, now that you are representing yourself, and you've made an oral motion to dismiss the cases, which I'm not going to do at this time, but you will need to, if the procedure we're going to follow is if you want to set these for a motions hearing, we'll set it for trial, and then we'll set a motions hearing. And at that time, you can argue for dismissal based on what I'm hearing is your perceived lack of jurisdiction. But today, though, you need to make a decision if you want to ask for a continuance of the cases or if you would like to set the cases for trial.
Well, I understand that's the binary that the court tries to railroad innocent people through, but it's my interpretation of what a court is constituted to do is you're the judge, you're supposed to be an impartial trier of fact. The prosecution, I'm not sure what Morgan's last name is because I can't quite make out how to spell her last name, but the prosecutor is required to provide evidence of personal and subject matter jurisdiction. If the prosecution has not provided evidence of jurisdiction as a threshold matter, the court may not proceed. And that's why I have argued, and that's why in federal court lawsuit, I articulated that the city hasn't been engaging in a RICO enterprise. Because without personal jurisdiction and without subject matter jurisdiction, when Judge Gregory and others issued warrants between $10,000 and $250,000, that was attempting to exercise unauthorized control over more than $5,000 of my money, which is a Class B felony under RCW 98.56.030, as well as extortion RCW 98.56.120. Okay. So you can set a motions hearing if you want to. Will I come here if I'm still in jail because I'm being forced to? I will. I'll do it under objection.
Okay.
And we'll speak respectfully and we'll do all that.
Okay.
But I don't agree to the court having jurisdiction.
I understand that. Okay, so, okay. It might be best, well, Ms. Carsonson, let me hear from you. I think it might be best to go ahead and set the cases for trial today, but the city, do you want to weigh in?
Yes, Your Honor, thank you. I appreciate that. The city doesn't necessarily have a position on whether it gets set for trial or is just a continuance. I happen to agree with Your Honor.
See, even at this point, right? She's asking for a trial, but the jurisdiction matter has not been clearly established. And what is that judge doing? Ignoring him. And this is where we lie the problems. They get to ignore us even when we bring out case law and this, that, here, and there. And we throw it in their face and all that, and they still ignore it because there's sovereign citizen immunity and other judges protecting them. And then you got other attorneys protecting other judges. So in this whole case, she wasn't even allowed to speak because, well, she's supposed to bring up the subject matter jurisdiction, and she sat there through the whole entire time, not one time denied. She's in silence acquiescence and tacitly agreed to his terms that there's no subject matter jurisdiction. She agreed to it. But when we are in silence acquiescence and tacitly agreed to their terms, we're liable. So they get to keep forcing jurisdiction that they do not have on us because of our tacit agreement. But she ignores it. What is that? That's one-sided judge. She has not been fair and impartial at all. On record, on video, as plain as day.
Seems like perhaps setting for trial is the best way forward in getting a motions date. I do have some availability for Ms. Outland, and just so all the parties here are aware, I'm merely the covering attorney this afternoon. These cases are not assigned to me, but I do have authority to set them for trial.
Okay, all right.
She has no first-hand knowledge of nothing, but she has authority to set a trial that she don't even know she has jurisdiction of. Sit and think about that, people. Really quander this, all right? Don't just look straight forward just because they're judges and attorneys or prosecutors. Look all the way around the subject matter. She literally has no idea whether they have subject matter, but she has authority to go ahead and proceed forward and set case when there has not yet been subject matter jurisdiction proven. Just saying. Really, really pay attention to these words and how everybody's operating in this.
So, Mr. Benjamin, let me put this to you. I know that you are disagreeing with everything that's happening procedurally today, but I'm still going to need an answer from you since you are now representing yourself. Would you prefer to continue these cases, to talk with the prosecutor handling your cases, or would you prefer to set the cases for trial today?
Hell no, you don't want that attorney, because he's not going to challenge subject matter jurisdiction and be railroaded in what they're doing now.
If those are the only two choices, I will never. I do not wish to forego my right to speedy trial.
Okay.
I do not wish to have a continuance.
Okay. I understand.
I am more than happy to engage in dialogue with the prosecutor's office, and if they need to be educated on why they don't have jurisdiction.
I would tell them, nope, I'm adding the third one, that I'm going to reserve my rights, all my rights. And if I see in a later date that I need to have an attorney, I may go ahead and proceed forward on that. You don't get to decide this, Judge.
I'm happy to walk them through that. But I think the most important issue right now is that I am being unlawfully restrained and detained in King County Jail and not a flight risk. I've lived in Seattle my entire life, and I've done everything I can to try to resolve these issues through the courts. And so
Okay, so Mr. Bench, let's stay on track with just the
Okay.
issue of, there are many things that you are objecting to and disagree with, I understand, but so let's do this. So in terms of, I've heard you say you don't want to waive your speedy trial right, I get that, so that means that we should set the cases for trial today. When we set the cases for trial, then you are still free to talk with the prosecutor, handling these cases to, to see if you can resolve them and or prepare further for trial. So that's your option. So what I'm going to
Objection. I deny them only options. There has not been any subject matter jurisdiction clearly established. We cannot proceed forward, Your Honor. I want my fast and speedy trial if you guys get subject matter jurisdiction, but before anything else, I want my due process enforced. So I deny the proceeding forward on this.
do, I was looking at the cases just to figure out where we are with expiration. So on all of these cases, Mr. Benchuk was either arraigned or made first appearance on July 5th, 2024. So bail was set. And so, wait, hold on just a moment. And so my calculation was that expiration was originally set 60 days from July 5th, and the court set it at September 3rd, 2024. And then let me finish. Subsequently, there were 2 hearings where Mr. Benchuf did not appear for hearings, and so the court excluded time. That would be a total of 19 days. And so, by my calculation, expiration would be 19 days past September 3rd, which falls on September 22nd, 2024, which is a Sunday. And so then to adjust for the weekend, that would take expiration to September 23rd, 2024. Okay, so hang on one moment. Okay, so Ms. Carsonson, what's the city's position in terms of expiration on these cases?
Yes, Your Honor. The city agrees with the court's analysis, including the exclusion or refusals, and does believe that expiration would be on September 23rd, 2024.
Okay, Mr. Bench, would you like to weigh in on the expiration date, sir?
yeah, I object to the city's position on that as well as the courts.
Okay.
Because first of all, to back up, I was arraigned on case number 669329, supposedly on November 16th of 2022. And I was supposedly arraigned for case number 656748 in 2020. And my right to speedy trial was violated by a former Northwest offender, Crystal White, back in 2020. As far as the current alleged tolling, I would object to that first and foremost because I have been denied the right to appear in court unless I allow my religious beliefs to be violated. Specifically, I have been denied the right to wear my religious vestments upon my head. And after 4 weeks, nearly 4 weeks of filing complaints with the jail staff, they gave me a head covering, which I believe is called a kufi, which is of the Muslim faith. I am not Muslim. The only reason I am here today in the court is because I allowed my religious, I basically gave up my religious expression and freedom to come here.
Okay.
Because I felt it more important that I get things on the record and let the court know that the retaliations in jail continue, that I was put in the psych ward yesterday or by one of the jail staff who has been forcing me to wear a Muslim kufi to have my rights respected and be served food.
Okay, so Ms. Spencer, let me stop you there again. Okay, so I'm going to note your objection to the court setting expiration at September 23rd. I think you've made a pretty clear record of your position and why you weren't here at the last two hearings. So that is all noted. And so at this point, then I'm going to use that as the expiration date. Ms. Carstensen, do you have a trial setting order? Let's see, I'm not sure. Usually the trial setting order is generated by defense, but I don't know if the city is able to do that.
I don't know, Your Honor. I can log into Adobe right now. I should be able to generate such an order. If you could just give me a few minutes, I'm
All right, this is We the People News. Till next time, bye y'all.